Hi everyone, I am Radhika Pasari. I am an environment lawyer by profession. I have worked earlier as a legal researcher at the Legal Initiative for Forest and Environment for some time, which is in Delhi. Projects. Now, why this topic is important is that because both manufacturing and construction projects are crucial for the GDP target that India is aiming to achieve. Hence, even the compliance for safeguarding of the environment is equally crucial when it comes to these kind of projects. The laws are very vast, but I will be giving a general checklist of compliance laws for these two industries. Now, the first step prior to the commencement of a project is obtaining an environmental clearance as per the Environment Impact Assessment Notification 2006. There are three kinds of projects. Firstly, any kind of new project or activity. Secondly, for expansion of the already existing project. And lastly, any change in the project product mix in an existing manufacturing unit beyond the specified range. So this is specific to the manufacturing units. The schedule of the notification mentions two categories, that is category A and category B. This categorization is done based on the potential impact on the environment and the human health, which is created by the industries and the manufacturing units. And hence, the impact assessment as well as the public consultation is very important, which is included in the impact in the environment clearance process. There are subsequent amendments to the notification, which are category specific and needs to be kept in mind and read with the 2006 notification, which are all available on the Parivesh portal. The process of obtaining the environment clearance also depends on if the project is in any of the protected areas, which we will look at very briefly eventually. The EIA, which is the Environment Impact Assessment Notification, more or less covers every aspect of the impact that can be created by a project, but there are compliance under other legislations as well, which we will look at briefly. Firstly is the Water Act 1974 and the Air Act 1981, which concerns the water and air pollution caused by any industry or the manufacturing unit. Under the Section 25 of the Water Act, a new establishment or activity which is likely to discharge any sewage or trade effluent, is required to obtain two things, which are consent to establish and consent to operate from the central or the state pollution control boards, which are established under under the Water Act itself. The main idea behind this is to have a standardized mechanism to treat the effluents before discharging it into the water or before releasing it into the air, so that it reduces or even negates the harmful impact which is created by the industries. Similarly, in Air Act, any industry or process or operation in an air pollution control area is required to obtain the consent to establish and consent to operate. Now, the air pollution control area is not defined, but the state government, in consultation with the state pollution control boards, have the power to declare such areas in the respective states. So violation of or non-compliance with the conditions imposed by the board under the consent given can lead to withdrawal of the consent by the board and the operation can be stopped. Next is if any industry is being established in any forest area, forest clearance is required if the forest land is being diverted for non-forest use. So this is provided for under the Forest Conservation Act. Establishment of any industry or any building construction activity constitutes as a non-forest purpose. Therefore, it requires forest clearance, which is subjected to the approval of the Ministry of the Forest and Environment. And all of this process can be done through the Parivesh portal. Now, next is the added requirement for obtaining environment clearance for establishment of any industry or development project within 10 kilometers of any protected area. These are protected areas as defined and notified under the Wildlife Protection Act 1972. There are national parks, wildlife sanctuaries, conservation reserves, or community reserves, and these are defined under the Wildlife Protection Act itself. Now, the Act provides for the activities that are permitted or regulated in such areas. However, environment clearance for any activities that are to be carried out within 10 kilometers from these protected areas also needs to be regulated. And it is subjected to the recommendation of the Standing Committee of the National Board for Wildlife which is also called NVWL. And a separate application for wildlife clearance is to be submitted on the Parivesh portal. Now, this was not provided under the Wildlife Protection Act, and therefore it was done by a notification of the Ministry of Forest and Environment as per the orders of the Honorable Supreme Court. Another restriction is for establishment of any activities in the coastal regulation zone as per the coastal regulation zone notification 2019. The 2019 notification has come in supersession of the 2011 notification. The level of the restriction or prohibition of the activities depends on the categorization, which is the CRZ 1 area, 2, 3, and 4, and there are subcategories as well. As per the notification, the coastal zone management plan was to be prepared for all the coastal states, and the projects and activities gets appraised as per these plans. So the CZMP as prepared in 2011 is to be used in case these plans haven't been upgraded as per the 2019 notification. And for the plans which have been upgraded, the 2019 CZMP will be used for the appraisal of the projects. This separate requirement for coastal areas were made as these areas are extremely sensitive, as well as important ecosystem which supports a large biodiversity. This compliance list that I've provided till now is not exhaustive, as certain ecologically important areas also need other layer of protection. For example, wetlands are there, or flood-prone areas are there, and even states might have their own separate laws and regulations. So all of those also need to be checked with specific requirements. Why these compliance of these regulations are absolutely necessary is because apart from the specific violation provisions which are provided for in these acts and regulations and rules, these can be brought before the National Green Tribunal also, which is the adjudicating body. The National Green Tribunal was established as per the National Green Tribunal Act 2010. Now, the section 14 and 15 of the NGT Act provides for the jurisdiction of the National Green Tribunal, and section 16 provides for the appellate jurisdiction. There are certain reliefs and restitution which can be granted as per the Act. So Schedule 1 of the NGT Act lists down the legislations that are within the purview of the tribunal. Therefore, it is not only in the benefit of the environment that these laws and regulations are followed, but also for the manufacturing industry or the other construction project proponents to comply with these regulations, so they are not subjected to the adjudication before the NGT, and so that the environment can be protected in a holistic manner.